Hello, this is attorney Marco Schiavo from Simmons and Schiavo. Today we're going to talk about intent and making sure we have clear intent in our estate plan. Most of us leave assets either outright or in trust for our surviving spouse, and then when we're both gone, it goes equally to our children. But sometimes it just isn't that straightforward. We might be in a second marriage situation. In that case, we decide to leave amounts in trust for our surviving spouse, and then when he or she dies, the remainder of what's left is distributed to our children. But every dollar that the surviving spouse spends is one less dollar that our children will one day inherit. So it's sort of a dilemma there, because he or she only has a step relationship to our biological children. Things could get a little messy when it comes to our money and assets. When we have this kind of delicate interpersonal relationship that's going to affect our estate plan, it's imperative that we get the intent documented. It might be written inside the trust itself, including the reasoning behind the bequest or lack of bequest. Or sometimes it will make sense to write a separate letter explaining why we are choosing to do what we do. Without an express clear intent, others might try to fill the gaps after our death as to why we did what we did. They could claim that we weren't in our right mind when we left such amounts to our second spouse, or they could claim undue influence. The complaining party could file a court action declaring that absent the influence of a party who otherwise benefited from our action, then we wouldn't have written the trust the way we did. Aside from worrying about challenges to the legal documents themselves, we have to guard against challenges to the way our wills or trusts are administered following our passing. I'll explain. Suppose that Bob leaves assets in trust for his second wife, Mary. Mary is to receive the income from the trust for the remainder of her life, and she can take principal from the trust if the income is insufficient for her health, maintenance, and support. Now suppose that Mary buys a new car. She withdraws amounts from the trust to pay for it. What if Bob's children challenge the withdrawal? A child could say that Mary could have bought a less expensive model, or even a used car. This would have preserved more of the trust for the children to inherit once Mary dies. So what happens now? Imagine that Bob included language in the trust that says, during Mary's lifetime, Mary shall be the primary beneficiary, and her needs should be first considered, notwithstanding the effect that it may have on the inheritance of my children. Doesn't that language change Mary's position? It strengthens her position. Now instead, let's add a scenario where Mary has plenty of her own assets. Bob still wants the trust to pay her income, but she should only invade the principal if she doesn't have sufficient assets of her own. Now Bob's trust reads, during Mary's lifetime, the trustee shall pay Mary the income from my trust. The trustee may also pay Mary from the principal of my trust for her health, maintenance, and support, but in doing so the trustee shall first consider Mary's other assets, income, and resources available to her for such purposes. Do you see how the two different provisions give all of the parties more clear direction on what Bob wants for the trust to pay for and what Bob doesn't want the trust to pay for? Can you also see how each one of the provisions gives more specific direction than a general clause that says, pay Mary the income and principal that she needs for her health, maintenance, and support? Statements of intent really go a long way, not only to thwart a challenge to the estate planning documents in their creation, but also in providing clear directions to your loved ones, which should result in warding off conflict between them, which is important to us all. If you'd like more information, please give us a call at 781-397-1700. Again, 781-397-1700, or visit our website at www.simmonsandschiavo.com, www.simmonsandschiavo.com. ANDSCHIAVO.com. Thank you.